himself with Justice Stevens on a respectable test for equal protection of the law. He has said that on privacy he retains some discretion not to follow Wade versus Roe and to disagree with Griswold. But he has left himself wiggle room, running room, saying at the same time that stare decisis will determine it. There are a series of criteria, reliance, and generally accepted principles as to what stare decisis means. So that there is a sharp divergence between the writings of Judge Bork and the speeches of Judge Bork and the presentation of Judge Bork, the candidate who appears in this committee room. Now, my hypothetical question for you is, assuming that the only views on Judge Bork were those expressed in this Senate hearing room, would you think it appropriate to confirm him?
I address myself first to that issue. Let me say that I think a certain amount of campaigning, as you have put it, on behalf of anyone who appears before your committee is to be expected. I would also think that if I sat in your seat, Senator, and that of the others, I would discount that a good deal. I've already made one comment on it and quoted a proverb which is current in New England on the subject matter. He is here, he is making statements here, I think he is being honest about it, but I think that he has previously expressed his basic sentiments, and I know that when those cases are variations of them, as Mr. Smith has said, before the court, if Mr. Bork is on that court, Mr. Bork will let his fundamental non-sympathy with those basic cases influence his decision in cases which relate to them.
Mr. Meserve, let me just interrupt you for a moment and call to your attention a statement made by Chief Justice Berger, which I felt was weighty. He said that frequently in the deliberations of the court, and I thought it was an interesting insight, that the court finds doctrines applicable that they disagree with, but they apply the settled law even though they disagree with it. Now, it's been widely quoted that Judge Bork has said he does not want to be disgraced in history, and he takes the oath very seriously. And I focus those factors I call those factors to your attention, focus them as you respond to the question as to what our expectation might be as to Judge Bork's applying settled principles in a conscientious and good faith way.
I can't get into Judge Bork's mind any more than you can, Senator. I know what he said, and if I was sitting in your place, I would be governed by what he said at a time when he was under no pressure and had no personal gain to reap from or to obtain from his answer to the question. I don't doubt that there is a ecumenical spirit of deliberation amongst the justices of the court. I've never been privileged, of course, to share in it, and nobody's ever suggested that I should, but I think very seriously that they enter that with, as we would do as human beings, with our preconceptions and with our doctrinaire approach if we have one. And therefore I say that I think that you should consider what he said, surely. You should also consider the motivations that were his when he testified before you, and you should consider what he has said before and figure out whether or not, in those areas in which I am concerned as you are concerned, human areas, he is going to react as you would think a judge should react to the presentation before him. May I make one further observation? Which
yes, you may, but would you first focus with precision on my question?
I thought I had.
No, you haven't. Assuming, my time is up, assuming a hypothetical that the only evidence on the record was the testimony of the witness, Judge Bork, in this room, assuming that's all we knew about him, that he's going to follow Brandenburg, that equal protection applies to women, assuming that all we know about him is what we saw when he sat in your chair, what would you do? What's your verdict?
I would determine my verdict, sir, on the basis of the credibility I would give to that statement, having in mind the position in which Judge Bork found himself.
Senator, if I might add something to that.
Very briefly.
I wouldn't, if I were in your position, confirm somebody on a record of 3 weeks. and that's the problem with the question. The words that are used have to be read in the light of other things that he said. And one of the things, with respect to the question about the original intent, is that when it's been appropriate to him, his view of original intent has been pretty terrible. He said, and it's in that famous article on neutral principles that everybody's quoting, a couple of things. And I just want to quote two sentences. One of them was, he said, "The First Amendment, like the rest of the Bill of Rights, appears to have been a hastily drafted document upon which little thought was expended." And with respect to the 14th Amendment, he said, "Many or most of them," talking about the writers, "had not even thought the matter through." That doesn't seem to me like someone whose view of original intent is other than what is said about most members of the court, which is it is their version of it. Nobody was sitting with the founders that day who is around now. You have to judge by what the individual justice or justice-to-be says about them to evaluate what they're going to do when they sit on the court.
Thank you very much.
Thank you. The senator from Ohio, Senator Metzenbaum.
Mr. Chesterfield Smith, you're past president of the American Bar Association. As a matter of fact, I think your name is almost synonymous with the ABA. You've heard the charges that the members of the ABA panel who opposed Judge Bork's confirmation are politically motivated. In all your years of service with the ABA, do you know of any instance in which politics played a part in the ABA's review of judicial nominees, or do you have any reason to believe that politics played a role in the ABA's review of Judge Bork's nomination?
Well, we always have to define the terms. I'll start off by saying that I cherish and love the ABA and its processes. I have never been intimately involved with the Federal Judiciary Committee except as an appointing authority and I guess an oversight authority to that extent. What politics means, I don't know. I try to feel like I'm nonpartisan. I'm sure everybody else thinks that. I was a Democrat because that's all we were in Florida when I was born. I voted for Reagan once and Nixon once and regretted it, but I also voted for Johnson once and Carter once and regretted that. So it's hard to know, but I think that those people who dissented on that committee, if the rumors that are in the Washington Times or wherever it is, legal magazine that I saw, they said 4 names, yes they were. Those are 4 of the best lawyers I know who cared deeply about justice, and I can't believe they'd subvert the process for partisan reasons as distinguished from political reasons. So I like those people, and they've done so much good in my time to help advance what I believe to be the proper values of lawyers.
Thank you. Mr. Meserve, you also have been a distinguished and well-renowned president of the American Bar Association. And as you know, the American Bar Association was not unanimous in concluding that Judge Bork is well qualified to be an Associate Justice of the Supreme Court. Much has been made of the fact that, well, he did get 10 votes, 4 against him, and 1 was not opposed. Would you care to comment on how unusual such a split recommendation is, and do you know how far back we would have to go before members of the bar to a prior instance in which there was a split decision with respect to the recommendation of a nominee to the Supreme Court?
Senator, I'll have to plead ignorance. I have been acquainted with the decisions on other nominees to the Supreme Court. I simply don't remember any case in which there was a split vote, but there may have been, and my acquaintance is pretty extensive. It goes back to 1961 or 2, but I must say that I do not remember whether or not there was a split in that body in the determination of the issue.
My understanding is not since the nomination of Judge Hainsworth has there been a split.
I would accept that. I would accept that, Senator. I think that's probably true.
I think there was a split on some the early nominees in the Nixon administration. I could give their names. One of them was Herschel Friday, if I remember, and another was a woman judge from Los Angeles.
No, I'm talking about nominees to the Supreme Court.
That's what I had in mind. Oh, there were many splits.
I'm talking about nominees to the Supreme Court, too.
Yes, you're right.
Was there a...
There was a split on the committee, and they were withdrawn by President Nixon, as far as I recall. Those are my recollections.
Mr. Kaufman, would you care to comment, been some suggestion as to whether or not your view reflects, of the Executive Committee, reflected the position of the 17,000 members of the association? Do you have any indicia as to whether or not it did or does not?
Well, Senator, the best I can say is two things. One is that the composition of the Executive Committee, which is elected by the members, is a very broad range of the profession and of the bar in New York, and we believe that it does represent the membership generally. The second thing that I would say is that Senator Simpson made reference to the 53 members who've submitted a statement to this committee in opposition, and I suspect there are others. The comments that have come to us since the statement was made have been overwhelmingly in favor of the statement, and I must assume, since it follows in the process of the association that represents the membership, I should point out two other things. Two separate committees of the association, other than the Executive Committee, have dealt with this issue and made a recommendation to the Executive Committee, and both of those were unanimous. One was our Committee on Civil Rights, which is very heavily involved in the process of the kinds of issues that are before the court, and the other was our Committee on Sex and Law, which has a great interest in some of the issues before the court, and they both recommended unanimously that the Executive Committee oppose the Bork nomination.
Thank you very much. My time has expired.
Senator Humphrey from New Hampshire.
Thank you, Mr. Chairman. First, for Mr. Smith, is it correct that you are a member of the Executive Committee, or were anyway, in 1986, the Executive Committee of the National Lawyers Council?
I don't know. I don't even know what the National Lawyers Council is. But
Well, I think I'll just drop that one. Apparently, we have information that you
I belong to all kinds of things.
Yeah,
in a small town, you join everything.
I well understand. I'm a member of some things of which I'm not even aware. It turns out from time to time, so I won't press that one. Mr. Kaufman, at least 53, excuse me, members of the New York Bar Association claim that the Executive Committee, which I guess you are the chairman, does not have authority to issue the statement which it issues. You claim that it did, but at least 53 members, including 5 sitting federal judges, no less than 5 sitting federal judges, and a retired Court of Appeals, Federal Court of Appeals judge, claim that the association has no such authority. Nonetheless, there isn't time within 5 minutes to settle that point. I simply wanted to cite the fact that some very credible people claim that that you don't have the authority to speak for the New York Bar Association in this matter. For the rest of my time, I just want to counterpoise, for the benefit of those who might be tuning in today for the first time, counterpoise to the testimony of the New York Bar that some very impressive people feel pretty strongly about the qualifications of Robert Bork, including 8 former presidents of the ABA, not the New York City Bar Association, but the American Bar Association, 8 former presidents who support the nomination, 2 sitting justices of the United States Supreme Court, a retired Chief Justice Warren Burger, who said when he appeared the other day, in response to the question, is Robert Bork someone whom black citizens and minorities and women need to fear? This way, quote, if they need to fear him, they should have been fearful of me. I can see nothing in his record that would suggest or support it. Justice Stevens, I referred to 2 sitting justices who support the nomination, one of whom is Justice Stevens, who says that Bork's judicial philosophy, quote, is consistent with the philosophy you will find in the opinions by Justice Stewart and Justice Powell and some of the things that I have written. Now, you're entitled to your point of view, as are all of the witnesses, but I think from time to time we need to counterpoise these negative opinions with some from some positive opinions from some very respected people. And in whatever time I have left, I'd like to, for my part, to address Mr. Meserve. By the way, we have a township in New Hampshire named Meserve's Reserve, or something like that. Nobody lives there, but it's there.
I understand nobody living there.
It's a piece of land that was carved out for some purpose and has the name Meserve attached to it.
My origins are in your state.
You seem to say, I think I came in midstream in your testimony and I didn't catch all of it, but you seem to say that Judge Bork is qualified in all respects which the ABA uses as criteria, but not in some other respect which apparently you labeled as political. Is that correct?
That is absolutely correct.
Well, if I had a gold medal, I'd march right over to where you are and pin it on your lapel, because much as I dislike your testimony, I have to say that among the opponents of the nomination, you are the most intellectually honest of any who has yet come before this committee, because you're admitting your opposition is political. And
yes,
I believe that the opposition of most of those who appear in opposition is political in nature.
That's due to my New Hampshire origin.
I'm not surprised to learn that, I salute you for your intellectual honesty.
Thank you. I just want to make one observation, if I may, on a personal basis. Senator Kennedy was kind enough to refer to my service as an assistant United States attorney recently. There are those who would say, having gone through the travails that Senator Simpson described, that I made enough money as a trial lawyer so I could work for nothing for anyone who would give me something to do after retirement. That isn't quite true, but the complaint I wish to register is the amount of mail that I get as a result of my one-time charitable endeavors from Senator Kennedy's church and from my Jewish friends and other organizations I don't belong to. The very fine black mail carrier who carries the mail to my house complains occasionally of the volume of solicitations that I receive thanks to my adventures. Thank you.
Thank you, Mr. Chairman. My time has expired.
Do either of you gentlemen wish to respond to anything stated?
I'd just like to make one comment, because I think perhaps Senator Humphrey may not have been in the room when I responded with respect to the 53-member statement as to what the Constitution of the Association of the Bar says. If they're right, we've been doing something wrong for 117 years, because our association was founded to deal with the process of the selection of judges through what was then a pretty terrible process in terms of the criteria that were used, and it was established to improve the judiciary, and I think we've worked on that for 117 years, and I just have to disagree with them. Thank you.
May I?
Sure you may, Mr. Smith.
Senator Humphrey, for your information, when a gentleman from Montgomery with the ABA Judiciary Committee called me, my statement back to him is that I would find Judge Bork exceptionally well qualified. However, if I were either president or a senator, I wouldn't put him on the Supreme Court. That you can draw the same conclusion. That
You're saying that your opposition is political as well?
yes, sir. If you could characterize that as political, I say I don't think he's the man for the job. That's all.
There is a vote on, gentlemen. Yield to Senator DeConcini, and then I'm going to go vote. And
Mr. Chairman, I don't have any questions. I'd be glad to yield to the next person in line.
we then go to Senator Leahy, because the next one to question over here is Senator Hatch, and I told him to go vote now, so he'll be right back. Senator Leahy, and then I'm going to vote. And Senator Leahy, if you will shut it down for a moment till I get back, if you have to go vote in the meantime, okay?
Thank you all.
And the panel, do not leave, please. It's a
Thank you,
vote.
Mr. Chairman, and I will keep it brief. I do also appreciate having you all all here. Mr. Smith, I know that when you were president of the Bar Association, I heard a number of good things from some of my Vermont colleagues in the Vermont Bar about you. One comment made by one was that you're the sort of person who want to be the senior partner of his law firm, which when you gain that from one of these dyed-in-the-wool Yankees from Vermont, you know it's a high compliment.
I like it.
Mr. Kaufman, your organization, the City Bar Association of New York, has to be considered by anybody's standards one of the most prestigious of all bar associations, and has provided guidance to this committee, not only on this important nomination, but on two recent ones for the Federal District Court in New York, Rena Raji and Richard Daronco. And I mention those because I've been given the assignment, for better or for worse, of chairing most of the hearings and screening other judicial nominees this year. And I wish in all the nominees that I've had from all the other states that we could have the kind of report that we received from your Bar Association on those two particular nominations. Make things a lot easier. In fact, as you may recall, we moved fairly rapidly on both those nominations, and helped in large part because of the not only the in-depth job done by the City Bar Association of New York, but also because of the credibility, bipartisan credibility, given to the report you have. And I mentioned this, and I've dwelt on it just a bit longer than I would normally, because I noticed by the New York Times that there was criticism of your Bar Association on the report in the split involving Judge Bork. And I want to note that what I have seen so far, and the reports received from you have been very, very good, from the Bar Association have been very, very good. They have helped to expedite a number of nominees made by President Reagan, and supported by a number of the hierarchy in the Republican Party in New York. And because of the credibility I've given, is one of the reasons why they moved so rapidly forward. And I note that because you can't say that that same group that is so credible when it is supporting a Reagan nominee is suddenly not credible if it has members who do not.
Senator, I appreciate that comment very much. If I might just interject a moment, I appreciate it particularly coming from you. About 100 days a year I'm a Vermonter, and about 250 days a year I'm a New Yorker, and so that your comment that touched me particularly.
Well, thank you. I had to step out of here for a couple of minutes, a few minutes ago, to take a phone call from my daughter, who was calling from our farmhouse in Vermont, who says at least in northern Vermont the colors are probably going to peak this weekend, so if part of your 100 days are around this time of year, you ought to get up there.
They sure are, Senator.
The Vermont Bar Association also had a vote on this. They voted with not all members polled, but those who did vote, the weekend Bar Association meeting a week or so ago, voted to oppose the nomination of Judge Bork. And I think we have to agree this is this is something bar associations, I think, properly should be involved in. I think bar associations and members of the bar, leading members of the bar, should feel free to express their views. I know in my own state, I have elicited views from leaders in the bar, and I've had some who come in very strongly for Judge Bork, and some who come in very strongly against Judge Bork, but have taken the time to express it, and I think that's important to the Senate. Mr. Smith, you spoke to that, to the extent of what you want to see on the Supreme Court, and Mr. Meserve, you said that as I recall your testimony, your 5 children and your 10 grandchildren.
Yes, sir.
Am I correct, will be affected by this? Well, my children are going to live most of their lives in the next century. They're going to be affected by it, too. I think it's important.
I might add, Senator, since you referred to me, that one of the greatest pleasures I've had in recent years is serving as a trustee of the Vermont Law School, a very fine institution. And my daughter, who unfortunately could not be here, is a graduate of Middlebury College, which I believe is located in the middle of your state.
It very definitely is. In fact, the senior senator from Vermont, Senator Stafford, is a graduate of that, as is his wife. Very lovely school.
Senator,
Yes, ma'am.
If I can comment on the process, because I think we can assure you that the process you saw in the evaluation of the judges for the district court by our Bar Association was done with the same care and quality here, if not more so, and that the members of the executive committee sat with members of the same judiciary committee, and many members of the executive committee were members in the past of the judiciary committee. So we can assure you that the process was of the same high caliber that you have seen in the past.
Thank you. You anticipated my final question, and I appreciate the answer, and we will stand in recess for 10 minutes. I understand Senator Biden had suggested that Senator Hatch could, having come back from voting, go ahead with his time, and if you don't mind, we will do that.
Is it okay to proceed, Pat? Okay. Well, welcome to all of you to the committee. These have been difficult hearings, and of course, we appreciate the respective points of view. Now, Mr. Kaufman, you're appearing here on behalf of the City Bar Association of New York. Now, before you decided to come to testify, did you survey your membership to determine the support of your entire membership for your particular position you're taking today?
No, we did not, Senator, and we don't do so with respect to the many issues on which we comment. While you were out, Senator Leahy commented on our testimony here on 2 recent judicial candidates for the district court. We have procedures and committees which report to the executive committee. I also commented while you were out, Senator, that 2 committees had recommended unanimously to the executive committee that they take this position, and the executive committee is charged under the Constitution with making the policy of the association.
Well, let me say this. That doesn't sound very democratic to me, but be that as it may, you have a right to make your rules, but I think that you need to change your rules, because I'm getting a lot of calls and a lot of complaining from members of your bar who feel that you don't represent them. And as you're no doubt aware, the New York Times, as has been brought up, has reported that at least 53 of your members, including 5 sitting federal judges, Judge Thomas Grisa, Judge Milton Pollack, Judge Sprizzo, Judge John M. Walker Jr., and Judge Dudley Bonsall, who once served as president of the New York Bar Association, harshly criticized your actions as, quote, unauthorized, unquote. Well, as, quote, unauthorized by the membership, irregular and political in nature, unquote. And they were joined, were they not, by retired Court of Appeals Judge William Mulligan. Is that correct?
That's correct, Senator, and I would suggest that any organization of 17,000 members will have more than 53 who disagree, and many of them will be distinguished.
I think you do have more than 53. I'm naming some very influential, important people whose viewpoints should not be ignored just because of your bylaws and your particular association. It's interesting for me to note that the U.S. Attorney in Manhattan, Paul Curran, stated...
Former U.S. Attorney,
Yeah,
Senator.
former U.S. Attorney in Manhattan, stated that, quote, the question is whether the executive committee has run away with itself, whether the members are anointing themselves with power the bylaws don't give them, unquote. Now, indeed, this prominent lawyer and others have resigned to protest what they consider to be a, quote, political, unquote, move. I would simply like to enter into the record at this time, and I will do so since there is no objection, and I'm sure Senator Biden would go along with that, the article to which I referred in the New York Times, entitled New York Bar Association Split Over Its Stand on Bork. Now, let me just ask all of you, were you in support of Justice Scalia when he came up for his nomination last year? Let's start with you, Mr. Smith.
Yes, sir, I was. I care about a balanced court, and I thought that that
Fine, I just
added
want to know whether you were in support of him. Mr. Meserve?
I didn't appear before this committee, but in response, I believe, to Mr. Lancaster's inquiry of me, he being the First Circuit representative, I expressed my opinion that Mr. Justice Scalia was a man of real standing. He's a graduate of Harvard Law School.
All right, Mr. Kaufman, so you would have supported him had you been asked to.
Oh, if I had been here, I probably would
Mr.
have.
Kaufman?
Let me comment for the association. We did not comment on Justice Scalia's nomination. I described early in our testimony the process by which we had determined, while no nominations were pending, that henceforth all Supreme Court nominations would be reviewed. It was after Justice Scalia's confirmation. My own view is that he's a very fine judge.
Fine. So all three of you would have been for him personally, and you think the administration...
Yes, Senator, I do want, in view of your comments to my brother on my left, I do want to say that I don't think there's any split in my constituency, although my younger granddaughter at times has expressed some disagreement with policies that I have inaugurated.
And when she gets older, she's going to look back on this and say, Grandpa, you should never have done that.
Maybe she will, Senator. I can't predict. There is a certain amount of dissent amongst my children and grandchildren, but usually when it comes to public positions, they're with the old man.
Well, but out of the mouths of babes comes tremendous wisdom. And in this case, I want you to get back and listen to those grandchildren.
I hope that is true.
Well, you all three would have supported and did support Judge Antonin Scalia in 1986. Now, it's difficult for me to understand how you could have supported Judge Scalia and failed to support Judge Robert Bork, except for Mr. Smith's comment. Because Judge Bork voted with Judge Scalia 98% of the time on cases that they both decided. And on the one case where they differed, the Ullman case, Judge Bork granted far more liberal protections for free press and drew a dissent from the more conservative Scalia. And if Scalia was qualified for the Supreme Court, certainly I'd have to conclude Bork is as well. And I think any honest person would. The only distinction between the two is this bogus, I call it a bogus balance argument. But on the grounds of balance, if you use that argument, Hugo Black would never have served on the Supreme Court because he replaced one of the most conservative members, Judge Vandevanter, as I recall, on that court. Nor would Goldberger have ever replaced Justice Frankfurter. Nor should Thurgood Marshall have ever replaced Tom Clark. Nor should President Roosevelt have been allowed to place 8 members on the court. And you could go on with examples. If the balance argument had been adopted in the past, we would still be governed by the erroneous doctrines like Plessy versus Ferguson, the separate but equal doctrine. In fact, the balance argument is just a way of saying, as I view it, and I think as anybody who looks at it carefully views it, that you disagree with the way the 5 members of the court might vote. And it's a wholly result-oriented argument that amounts to attempting to dictate the outcomes of cases by dictating who can or cannot be on the court. And
Well,
it's dictated, it seems to me, by people who basically resent President Ronald Reagan as president and his right to nominate people of quality and standing who basically he hopes agree with him. And as you know, there's no way you can tell what a Supreme Court justice is going to do when he gets on that. Let me make a couple of other comments, and then I'll turn to you. Once again, I wonder out loud whether justices of the quality of Justice Felix Frankfurter, Hugo Black, and others would ever have been confirmed under this, I think, phony balance argument. Now, that's what bothers me. One last comment, and then I'll quit. And that is that 5 years before, the Bar Association, the American Bar Association, rated Judge Bork exceptionally well qualified, the highest rating a judge could have, or a person could have for the Circuit Court of Appeals. That rating, of course, was unanimous at that time. 5 years later, after what many, I think most, would have to admit is a sterling judicial record, never reversed, 400-plus cases, with the liberals and conservatives on the court, and in many, many of those cases, you go on and on, we've done that here. Politics are played, and although 10 firmly come out with the highest rating anybody can have for the court, 4 come out and rate him politically based upon their political motivation. Now, at least 2 of you have indicated that you are motivated primarily in your appearance here by politics. I think that's terrific that you admit that, because you're the only ones who have been honest enough to come in here and say, yes, this is politics. And yes, we honestly don't think he should be on the court because we differ with him politically. I would just submit to you that I admire you for saying that, because that's the truth throughout this matter.
Yes.
This is politics. And frankly, if you were elected president, you could have somebody of your persuasion on the court. It seems to me, as long as they met the same ethical and competency and judicial temperament standards that Judge Bork certainly can meet. And you would have my support.
Senator,
yes, sir.
may I now answer that lengthy question, if that's a question?
I didn't ask a question. I was just telling you what I felt. But go ahead.
I thought perhaps that was so. Senator, I feel very strongly that when we use the word politics, we may be using the word perhaps in different senses. Both Mr. Smith and I have supported for membership on this court, and the ABA committee, which we do not represent, has surely supported many people of both political parties. I happen to be a Yankee Democrat, and Senator Kennedy can tell you that's a fairly rare breed. But the fact is,
it's very strong here in this body.
And I had a Republican father and grandfather and 2 Republican brothers, but I still am a Democrat.
Now a bunch of Republican
But on the other hand, I am not speaking here as a Democrat or as a Republican, nor in that sense either Mr. Smith and I advocating a political situation. We see here in the true sense that this is a political determination, but we don't think it is a partisan determination. We think it is based entirely upon the fact that we have here a doctrinaire gentleman who has expressed his opinion freely and honestly before he appeared before this committee, at least, in support of principles in which we do not believe, which I don't think have anything to do with my being a Republican or a Democrat, a conservative or a liberal. I don't think we want a right-wing radical on that court, and I think that the true conservatives on that court, such as Mr. Justice Powell, who happens to be a very dear friend of mine and I think of Mr. Smith, I think they're the kind of conservatives that I would like on that court.
Well,
and I might say that would apply to the Chief Justice.
I have to turn to Senator Heflin, but let me just say this: I don't think
turning to me.
No, I'm not. I don't want any right-wing or left-wing radicals on the court, but I think it's highly unusual. You are the first one, I think, to come in and call Judge Bork a radical, and I don't think there's any justification based upon his record as Solicitor General or as a judge, and I think that even his writings can't be categorized as radical, even though he has fluctuated from time to time from one position to another, as law professors do, and as young lawyers do, and as people with open minds do, as you have done, as I have done, as everybody does who thinks in this world. Let me turn and give the time to Senator Heflin. It's his time anyway.
We're trying to do it. Senator Biden asked me to return. We've got votes on and then another one coming up, and so we're trying to see if we can expedite and get this hearing moving, and where we're not here next month. That's a realistic prognostication that we may have to be, but hope we can. I'm delighted to see this group. I've long known Bob Meserve and Chesterfield Smith. Go back many years, I reckon, even before they were president of the American Bar, when they were at American College of Trial Lawyers, and know both of them well. Know they are outstanding lawyers and have made great contributions to the bar, and we're glad to see the officers of the New York Bar Association here. I probably have more of an affinity with Chesterfield Smith. He being from the South and being a neighbor, but I do want to pay him the compliment that he probably got more lawyers involved in the American Bar Association than any president. I don't know why it came about. Some people said that Chesterfield represented the rough element in the Bar Association. And, but anyway, I reckon that's my affinity to you because I sort of always felt like I was in the rough element. I know that you, Mr. Smith, have had some thoughts about the balance of the court with a Southern person on it. Senator Thurman raised this quite an issue. I, in effect, somewhat said, well, we could look upon Justice Scalia, since he spent considerable time as a professor of law at the University of Virginia. But this not necessarily that this amounts to anything, but I bring it up merely for the future, not necessarily in connection with this nominee, but I know that you've expressed yourself some about that. Would you like to comment on that?
Yes, sir. I feel very strongly that credibility with the people is the most important single attribute of the Supreme Court, and to have it, that you have to have all segments of our nation, all segments of our culture and society represented on the court. I was born in Florida when it was the South long ago, and I feel that, as far as I know, this is the first time...
What do you mean by that remark? You mean that you...
There's a lot of other people down there now. So.
All right.
But this is the first time, as far as I know, since 1789 that there hadn't been somebody on the court when Lewis Powell left, from those great states going from Texas through Virginia and Maryland. And if I were the president in appointing somebody, I think I would try to see that all segments of the country are represented, and that would certainly include the South. If I were a senator, however, I couldn't initiate that appointment, but I could send a message to the guy that until he does get a balanced court and brings all segments of our nation together on there, that I'm not going to vote to advise and consent, confirm, and put him on the court. Now, I think that in addition to geography, that they ought to look at other elements of the society. I don't want there to always be earmarked a Jewish seat or a Catholic seat or an Hispanic seat or a Polish seat, but I believe all of those factors ought to be looked at by senators when they're deciding what's best for our nation. And the nation has to have credibility in that court and recognize that all views are there. So I want a Southerner there.
Well, you speaking about all those different elements, I reckon maybe that's the Florida influence. Is that it?
Yes, sir.
All right. Well, now you also brought out the one man, one vote issue, which you mentioned. Of course, I recognize certainly in my state and in many states that as a result of one man, one vote, that substantial change has occurred, not just because of racial members, but because also of geographical areas. I mean, there's no question that certain geographical areas were underrepresented, and many of them were in the old days before the one man, one vote concept came about. What is, you mentioned a fear of some implementation. Would you expand a little bit on that? I have some interest.
Yeah. I don't know exactly what Judge Bork thinks or doesn't think about one man, one vote. All I know is I don't want him.
Hold it just a moment. Senator Grassley, if you'd stay, I believe we could let you in about 2 minutes to answer, and then you can get the last if you'd like. All right.
My point was that in implementing one man, one vote, not knowing what Judge Bork would do or anything else, he's stated in the past that basically he approves a test of rationality as far as apportionment is concerned. Well, that's the exact crap that I used to hear from those people up in North Florida that had their hands on the throat of the people. They wouldn't reapportion the legislature because we've got a rational system. It's based on the Constitution. I don't want somebody deciding things that uses that. And that's why I am entitled. It may be bigoted, it may be biased, but it's based upon the way I live down there, and that's what people used to tell me. They believe in a rational system. And I believe in one man, one vote. Everybody ought to be the same.
All right, Senator Grassley would...
Thank you, Mr. Chairman. First of all, I want to, I didn't get a chance to hear the panel speak this morning because I had HUD Appropriation Subcommittee was meeting all morning prior to these votes. But I had a chance now to look over the list that we have before us, and obviously it's a very impressive list of people we're going to have this morning. But I think what's especially impressive about it, though, is that as we look to the first 8 witnesses, 7 from my judgment, already 4 so far proving this, are going to speak or 7 of the 8 are going to speak in opposition to Judge Bork's nomination. So those of us, Mr. Chairman, that want balanced presentation today, we're going to have to, it looks like, wait a long time, probably until late this evening to get that. Also, Mr. President, if I could, before I ask a question of this panel, I'd like to make reference to the fact that I've received an interesting letter from a constituent of mine. Diane Leiby of Des Moines wrote to me saying, and I quote, "Not all women are afraid of this nominee's confirmation. Not all women are swayed by historical rhetoric. Quite the opposite," she says. "There are many women and men in this country who are capable of making rational decisions about this nominee's fitness to sit on the Supreme Court without being influenced by the press and by senators and by being told how to interpret Mr. Bork's testimony by a third party." Mr. Chairman, I believe that Diane Leiby's letter represents a large portion of the women in this country, much larger than we've been led to believe. I've received, Mr. Chairman, over 6,000 letters on this nomination from people across the country, and I haven't had a chance to look at all of those, but I did take an opportunity last week to divide 700 of the 6,000 into randomly selected letters into 2 piles. And these were letters received from men and letters received from women. And of this male count, an interesting thing is that 57% of the women who wrote me said they wanted Judge Bork confirmed. Now, people can talk all they want to about organized women's groups, but I have a tall stack of letters from individual, independent women who know that Judge Bork is going to serve them fairly. So, Mr. Chairman, since this letter from Diane Leiby was written in the way of testimony, I ask permission to have it inserted in the record.
All rights without objection.
Okay, thank you.
Be so limited.
I believe the one...
In you, so it gets in the record.
Okay. I think that probably my question is best directed towards Mr. Smith, because you're the one that I think first brought mention of balance to this discussion. Many people are saying that Judge Bork's nomination should be rejected because Justice Powell, though he may be conservative, is not as conservative as Judge Bork, and therefore Judge Bork's going to tip the balance. Are you, Mr. Smith, aware of Professor Tribe's recent book on the Supreme Court?
Am I aware of it?
Yeah, aware.
If I got to discuss it, I better say no, but I am aware of it.
Okay. Well, in it he cites 2 examples of appointments that shifted the balance of the court. He stated that Hugo Black's appointment in 1937 decisively shifted the court into one that would stop the upending of FDR's legislative program. And then he cited cited Justice Goldberg's appointment in 1962 as the other example, and that's where the balance was shifted to give the Warren Court a very solid majority for its overexpansive views. And I take it in those instances, you and many others were quite happy with the shift in the balance of the court. Would that be fair for me to...
Well, I wasn't happy.
You weren't happy with it.
I didn't know much about Justice Black, but I wasn't happy about that at all. I believe that the court should be in balance. The American Bar Association, which I do not speak for, but I say I'm proud of it, they stood up to President Roosevelt in one of the great days of their history. They opposed him trying to pack the Supreme Court and change the philosophy of it. They believed that we should go through the processes. I would have done the same thing if I'd have been a little older.
Well, when we talk about balance in the court, doesn't it really get down to whether or not those objecting to this perceived change or shift in the balance of the court are really only objecting because they want to preserve the balance that they like? Isn't that what it is in the final analysis?
I think that's not unfair for you to state. I supported Justice Bork and Justice Scalia going on the Circuit Court of Appeals for the District of Columbia because I thought that court had gotten out of balance and that their appointment brought it back in balance. But, you know, I got rational reasons that somebody else doesn't like all the time, and I think that I feel that the President and the Senate can find somebody that serves the national interest better than Judge Bork, but that may be a rationalization on my part, and I have to acknowledge that.
No, I think your statement just makes the point I was trying to make, that it varies from whose ox is being gored, whose interest is being heard as they perceive it being heard, or whose interest is being helped as they perceive it being helped. But on top of that, though, I think we've got to remember that both opponents and proponents of Judge Bork have not questioned his qualifications from the standpoint of his research and his scholarly activity and what he's done on the Circuit Court of Appeals, his qualifications. And I think that ought to be paramount with those of us in the Senate.
He is a brilliant jurist and lawyer, and I respect his intellectual qualifications without reservation.
But
I might say, sir, that I join in the answer of Mr. Smith, but I just want you to know, Senator, if it is not already clear on this record, that neither Mr. Smith nor I, as distinguished from my brother, are speaking for the American Bar Association. We are speaking for ourselves as American citizens and for our progeny.
Yeah, I appreciate that, and I knew that as well. Thank you, Mr. Chairman.
I believe Senator Humphreys has completed his questioning of this panel, so we will appreciate this panel coming and being with us, and we will adjourn until a Democrat senator comes to take over and to continue it. It may be momentarily, since this other vote is over at half-time. If I can turn off this device, I might do better, but hell, it won't.
Mr. Senator.
I don't know how to operate these newfangled operations, you know.
Senator, before we adjourn, on a point of personal privilege, thank you very much for listening to us. I just want to say as a Bostonian that when I hear my brother on the left say that the New York City Bar is the oldest bar in the United States, I object in the name of John Adams, if nothing else. And when I heard the nominee state that New Haven was the Athens of America, I felt that as a Bostonian I ought to take exception to that too. Thank you.
Well, we let you Yankees fuss a while there. But we're being recessed, and Mr. Sowell, if you will, stand by to momentarily assume the witness chair.
C-SPAN's coverage of the Bork confirmation hearings will continue after this.
Thousands of C-SPAN update readers knew in advance about our coverage of the confirmation hearings of Supreme Court nominee Robert Bork. The C-SPAN update helps you better plan your C-SPAN viewing time by giving you information on major telecasts like the Bork hearings, our Road to the White House series, National Press Club speeches, and more. call 1-800-453-4003 to order 50 weekly issues of the C-SPAN update. When you do, we'll send you a free copy of Gavel to Gavel, a 64-page guide to the televised proceedings of Congress.
Each Sunday, C-SPAN takes an hour-and-a-half-long look at process and policy. With the aid of experts, analysts, and those directly involved with public policy issues, C-SPAN offers a look at what's happening behind the scenes. And during the call-in segments of the program, you have a chance to ask questions and voice your own opinions. C-SPAN's Process and Policy, Sundays beginning at 8 p.m. Eastern Time, 5 p.m. Pacific.
You're watching C-SPAN, America's network. C-SPAN is a nonprofit cooperative created and supported by the cable television industry as a public service for its national cable television audience. In addition, C-SPAN is underwritten in part by the following.
The Bell Companies of Ameritech and its other communications-related companies, leaders in advanced technology, have helped make this programming possible. Ameritech, helping you communicate.
Coming up next on C-SPAN, we resume our coverage of today's Senate Judiciary Committee proceedings on the Supreme Court nomination of Judge Robert Bork.
We'll welcome your testimony. You've been here earlier. We'll try and follow as closely as possible the time limitations, but we want to give you an opportunity to get your thought across. So you may proceed in whatever way you want to. We'll include your full statement in its entirety in the record.
Thank you very much, Mr. Chairman, for an opportunity to present my views to this committee.
Let me just get a little quiet, we'll be quiet, please, so the witness can be heard. He deserves to be heard.
My support for the nomination of Judge Robert Bork to the U.S. Supreme Court began even before he became a judge of the Circuit Court of Appeals. I publicly urged that he be considered as a replacement for retiring Justice Potter Stewart some years ago, and then again as a replacement for retiring Chief Justice Warren Burger last year. So I'm, of course, heartened to see him nominated now, though I'm disheartened to see the confused, hysterical, and even dishonest terms in which that nomination is too often discussed in the media and elsewhere. This may be the most important Supreme Court nomination of our time, not simply because the present court is so closely divided, or even because Judge Bork is the most highly qualified nominee of this generation, but because this is an historic crossroads as regards the expanding power of judges, which is to say, the erosion of people's rights to govern themselves democratically. Gradually but steadily over the past 35 years, more and more decisions have been taken out of the hands of the American people and vested in courts. Those preoccupied with the merits or demerits of the specific issues raised in the cases involved pay little attention to the general drift away from accountable representative government. The ad hoc way many of these landmark cases of this era were based on legal principles improvised for the moment has meant that law itself has become more and more a matter of how judges happen to feel politically or socially about particular issues or particular litigants. No one has opposed these judicial trends more consistently or more ably than Robert H. Bork, first as a scholar and then as a judge. Mr. Bork has rejected the idea that judges should engage in heroic adventures in policymaking, as he calls it. The renunciation of power, he has said, is the morality of the jurist, not the assumption of power in the name of morality. What Mr. Bork has fought against consistently over the years has been, in his words, government by judges who are not applying the Constitution. Against this background of historic issues about the very meaning of law, it is both ironic and appalling that Judge Bork's own record is being judged on a myopic basis of an issue-by-issue statistical box score on how he has allegedly voted for or against one class of litigants or another, as if he liked chemical companies more than he liked pregnant women, or liked asbestos manufacturers better than he liked bereaved widows. Surely no responsible person thinks that this is what law is all about. Yet such shrill propaganda from special interest groups is repeated in respectable quarters as if the statistics represented some objective fact. Many people have no idea how utterly worthless and therefore deceptive such statistical box scores can be. Last year this time in California, there was a bitter election campaign over the re-election of the state Chief Justice. During that campaign, one side cited statistics to show that the Chief Justice had voted for defendants 85% of the time over a period of nearly a decade. The other side, using exactly the same raw statistical data for exactly the same span of years, concluded that the Chief Justice had voted for the prosecution nearly 90% of the time. Well, these are not small differences, either in terms of numbers or implications. Neither were they based on any esoteric statistical methods. All that they depended upon were differences in definition as to what was a vote for the prosecution. The statistics thrown around recklessly as to how Judge Bork has allegedly voted against women X% of the time or for some other class of litigants Y% of the time are no more reliable than the definitions used by the special interest sources from which they come. Arbitrary definitions are no less arbitrary when they are expressed in numbers rather than words. Taking these box scores seriously reflects either a dangerously naive gullibility about statistics or an even more dangerously cynical view of the truth. The same kind of box score approach has been used against Judge Bork in the racial area, except that all the things Mr. Bork has done to advance the civil rights of blacks and Asians are either ignored or played down, while every legal question he has raised about any portion of any civil rights law or court decision has been automatically defined by his critics as being anti-civil rights or anti-black. Obviously, I wouldn't be here if I believed any of that. The landmark civil rights cases which Robert Bork initiated or joined as Solicitor General have been dismissed by his critics because supposedly he was only the mouthpiece of the administration. But surely no one believes that someone with Robert Bork's marketable skills was so desperate that he had to hang on to a job that required him to perform duties which conflicted fundamentally with what he believed and wanted to do. Civil rights need to be understood not simply as a special benefit to minorities, but as something essential to everyone. Civil rights define a civilized and humane society. State-imposed discrimination was central to the racial oppression of blacks during the Jim Crow era in the South. Judge Bork opposed this central focus of racial discrimination, from Brown v. Board in the 1950s to Washington v. Davis in the 1970s to his work on the Court of Appeals in the 1980s. His criticisms of particular parts of particular laws and court decisions have often been in terms of the extension of constitutional rules from the government to private individuals and non-governmental organizations. These serious legal questions are by no means confined to Judge Bork. The law journals and law books have been full of controversies for decades over so-called state action. It was precisely this principle which many raised in the restrictive covenant cases, which are not simply cases about whether you are for or against housing discrimination. Demagoguery on this point is especially uncalled for, since no one, as far as I've been able to tell, has ever seriously advanced any evidence that Shelley v. Kramer or Reitman versus Mulkey made any discernible difference in racial housing patterns. The question is whether political symbolism was enough reason to justify trying to make the Constitution say something that it did not say. In our preoccupation with specific issues and specific groups, it is easy to forget that all groups stand to lose as Americans when the law is undermined as judicial activism surrounds all laws with a large and growing penumbra of uncertainty. Education in many public schools becomes impossible when the uncertainties of the law make expulsion of disruptive students difficult, costly, or a time-consuming ordeal. Yeah.
You want to summarize your
I think I have 10 minutes, was it? I have about a minute, another minute.
Fine.
No one loses more than the black community when their children are not educated or when judicial undermining of law enforcement makes their streets far more unsafe than they were 40 years ago. Legal principles are not just abstract intellectual matters. They are often far more important to far more people than the specific issues which provoke single-issue organizations to venom and propaganda. If more people will look beyond this propaganda to the enduring principles which should guide the law of the nation, I am sure that more will support the nomination of Robert Bork to the Supreme Court. Thank you.
Fine. I have no questions. I'll yield my time to the senator from Arizona, Senator DeConcini.
Thank you, Mr. Chairman. Mr. Sowell, thank you for your testimony, and in principle of non-activism and making legislative decisions at your reference, I happen to agree with you. Let me ask you this question. If you were a woman and you had read Judge Bork's writings and his speeches as current as just 3 months ago, where he clearly indicated that his definition and interpretation of the Equal Protection Clause of the 14th Amendment did not apply to women. However, I think 6 days ago he sat where you sat and said that it applied to everyone now. Would that give you cause and concern for a nominee to be put on the Supreme Court who for some 20 years had espoused a strong, sincere position on his part of a neutral principle of interpreting the Constitution that the Equal Protection Clause did not apply to women?
Senator, I just don't believe that anything that I've read by Judge Bork has ever said that the 14th Amendment does not apply to women. I think that what he said was that the standards he would use in interpreting that law, because the 14th Amendment clearly says persons. In fact, some people have even raised the question why there was a need for an Equal Rights Amendment, given that there was already the 14th Amendment, which is an Equal Rights Amendment. But I think there's a fundamental difference between saying that you interpret the 14th Amendment differently or that you interpret your test of it differently in the case of racial groups than in the case of men and women. He used some obvious physical differences in life expectancy, and things of that sort. Differences which you don't find necessarily between races.
What about his criticism of the poll tax? Does that trouble you at all, that someone would be going on the Supreme Court with a strong expressed feeling that legally there's nothing wrong with that, even though he himself says personally he opposes it, as long as it's not excessive?
I think the poll tax that he was talking about was $1.50, right, which I don't think is a crushing burden in any income bracket. There's a fundamental difference between those devices which were historically used to promote discrimination, such as heavy poll taxes in some parts of the...
You think it would not be unreasonable if there was a poll tax of $1.50? No. You agree with Judge Bork?
$1.50? No.
Yeah.
If you start getting into larger numbers, then of course we start having some problems.
In just 3 months ago, Judge Bork was quoted in WorldNet June 10th, 1987, as saying regarding the Equal Protection Clause, quote, "I do not think the Equal Protection Clause probably should have been kept to things like race and ethnicity, which means excluding women." Doesn't that tell you something about...
I would really have to see the context, Senator, because I have seen so many things out of so many contexts.
I'll give you a copy of the speech. Would you give that to Dr. Sowell, please, and show him? It's, what page is that on? It's at page 12, the bottom of page 12. If you read the question there, Dr. Sowell, in the middle of the page, you'll see what the context was for his answer, which later decisions in which the Equal Protection Clause is applied would you consider to be a logical further extension of the principle, or where would you think that the court has gone too far in applying equal protections, et cetera? And then you see the answer, and I read part of that to you.
Well, he says that if you're talking about having different drinking ages for young men and young women, that this violated the equal protection law. He thought that was going, that was trivializing the Constitution.
Yes, and you don't agree with that. I mean, you agree with his position.
Only in the sense that in some of the cases in which these things are extended to women, you can't do it mechanically. You cannot mechanically extend the analogy from racial minorities to women for a lot of reasons.
But in other words, if you were a woman, it wouldn't concern you that his position was that I don't think the Equal Protection Clause probably should have been extended to things other than like race and ethnic discrimination. And when he goes further,
if that was all he said, and this was the only thing I had to go by on a program, I don't think I'd give it very much weight.
That would not bother you in his earlier
I wouldn't give it
writings?
very much weight because, in other words, if he said a law journal article saying why he thought women were not covered under the Equal Protection Law, and I suspect that as judge, he has already ruled that women have in fact been protected.
Well, he stated here under oath that now he felt the Equal Protection Clause applied to everyone. And of course, that's to me.
Has he ever ruled as a judge that women simply do not have protection under the 14th Amendment? I would think that'd be headline news.
No, but he has written, I think, very clearly that he, up until he testified here, that he did not think the Equal Protection Clause should have been interpreted to include women, and I just cited one. And well, I take it your answer is
well,
that.
Well, no, he's talking about extensions of the
Equal Protection Clause.
Well, it depends what you mean by the further extension of a principle. I don't think for 1 minute that he would accept a law that said that women weren't allowed to drive cars.
Well, the question is which of the later decisions in which the Equal Protection Clause is applied. So he's referring to the Equal Protection Clause, and his answer is I don't think the Equal Protection Clause probably should have been kept. That probably should have been kept to things like race. And that's a troubling statement. I'm pleased that he came here and finally said, "Hey, I've changed my mind." That now it applies to everybody, and that I'm not stuck with those kind of statements that he's been making, but it obviously doesn't
because I don't think that it
concern you or frighten you by any means.
No.
Do you, going back to the poll tax, what about the one man, one vote decisions that he's made? Does that trouble you at all, that the judge has expressed some opposition to the Supreme Court, that it was in an activist role when it said that was unconstitutional?
Well, I think we're doing exactly the thing that I said shouldn't be done, and that is we're looking at it issue by issue. I think what he's objecting to is the way this was done and the legal principle it's established. So this principle now applies far beyond the questions of voting.
Well, if you don't look at it issue by issue, how do you determine what a person is going to do, whether it's Justice Rehnquist or Scalia or Bork, if you don't look at some issues? What do you do?
I don't think that you determine it, even when you do look at issues, that you look at the issues which were important as of the time that this happens, which is very different from the issues that are likely to come up over the lifetime of that justice. I can imagine when Earl Warren was confirmed, that if people had looked back over the issues that were hot at that moment and asked him about all of them, they probably would have missed most of the landmark decisions that he made.
Well, yes, and Dwight Eisenhower was quoted as saying that's the worst appointment he ever made. So maybe they didn't look at issues enough. I hope that if Judge Bork is confirmed and I should end up voting for him, I don't look back and say, boy, I didn't look at specific issues. That's the worst vote I ever had.
Oh, but Senator, you can't possibly look at future issues, which are the only issues he can ever vote on.
No, you can only judge based on his past, right? Because we don't know what he's going to do in the future.
But the past consists not only of different opinions, it consists of completely different issues than he's likely to face in the future. And that was the point about Earl Warren. That if you asked him, Mr. Warren, how would you vote about the president taking over corporations?
Are you saying that you don't think that the Supreme Court is going to address the women of Equal Protection Clause, address the issue of women under the Equal Protection Clause in the future, that that's all been put behind us now, and that racial discrimination or restrictive covenants are never going to be brought up in the future before the Supreme Court? Maybe you're right. I hope, but that'd be nice if there were no such cases.
I'm simply saying that the cases of one era are not the cases of the previous era. That's all I'm saying. I'm also saying the principles, though, the law should be the same from one era to the other if you're serious about having a Supreme Court.
Because, well, my time is up. Thank you, Mr. Chairman.
Senator Thurman.
Thank you, Mr. Chairman. Mr. Sowell, I want to congratulate you for appearing here. I know in a way it must be a little tough on you. But you have studied Judge Bork's record, and I'm sure you're familiar with it in general. As a member of the Circuit Court of Appeals, he wrote 150 decisions and participated in 400 decisions. And my understanding is that none of those have been overruled by the Supreme Court. Chief Justice Berger said that somebody called him an extremist, and he said, if Judge Bork's an extremist, I'm an extremist too. And then Mr. Cutler testified here strongly in favor of him. In other words, do you know of any reason why this man should not be confirmed?
No legitimate reason.
Or do you think he possesses qualities that a judge ought to possess to be on the Supreme Court, such as integrity, judicial temperament, professional competence?
Absolutely.
He has said here that he would be fair to blacks and fair to women, and what more can he do? And his decisions on the Circuit Court affirm that. And yet to keep on bringing up some statement he made maybe years ago. Well, people, as time goes by, sometimes they make statements or write articles for sake of argument or to bring out new points or show a new imagination or new ideas. But when it came to writing decisions, he wrote sound decisions that are in line with the other judges, such as Chief Justice Berger and the others. And Justice Potter Stewart, he mentioned him and others. And you know of any reason at all why this man should not be confirmed?
None, Senator.
And you favor this committee recommending confirmation?
Absolutely.
Thank you very much.
Thank you. Senator Leahy.
Thank you, Mr. Chairman. Just ask one question. Did you follow the statements that Judge Bork made on First Amendment rights, freedom of speech rights, during the series of questions that I asked him and follow-up questions Senator Specter asked him?
I can't quite sort all those out. I heard a lot and I read a lot about his views on free speech.
Did you feel that his answers here were at variance with his writings and statements over the past 15 to 20 years? In that area, in the area of freedom of speech?
I don't know. He sounded more moderate here than he did there. But on the other hand, Senator, if I went back to stuff that I wrote in 1972, in fact, I've had to make that decision, whether I wanted a book I wrote in 1972 to be reprinted. And that was just in the last couple of months, and I said no, because I don't want it out there anymore, because I've moved beyond that.
In 1971, he strongly criticized, in fact, some of the harshest criticism I've heard, in 1971 criticized the 1969 Brandenburg unanimous opinion of the Supreme Court in freedom of speech. Now, in his confirmation hearing, he converts that to a statement where he supports Brandenburg. Would you say that was a basic shift?
No, because that was a shift on where you're drawing the line on a particular issue. It was not a shift of legal principles. Everybody that I've read, going back to Holmes, who talked about freedom of speech, said, yes, you have freedom of speech in this area and that area, but at some point you draw that line. And for a man to draw that line here today and there tomorrow, but on the same general principles, doesn't strike me as a shift of principle.
You don't see his strong rejection of Brandenburg before the confirmation hearings and his acceptance of Brandenburg during the confirmation hearings as a shift?
Not when they're 16 years apart.
You don't see his rejection within just the past year or so of Brandenburg in his writings and speeches, as acceptance of Brandenburg during the confirmation
I haven't read them more
as a
recently.
shift.
I haven't read them more recently.
Thank you. Thank you, Mr. Chairman.
Senator Hatch.
You're widely published, you've lectured widely, you've appeared before many congressional committees, certainly before committees that I've sat on, and you're widely respected, I think, by people from all types of persuasions, and you've been a principal spokesman in many ways for ethnic America. We've repeatedly heard from leaders of the civil rights groups that judicial activism is beneficial to minorities. Now, do you agree with this? And why do you think that civil rights leaders in this country, or at least the top leaders of the civil rights groups, are so opposed to Judge Bork?
I don't believe that judicial activism has been beneficial to minorities.
Speak in the machine.
You
Yes.
need to pull that up just a little bit and get it close to you.
I don't think that judicial activism has been beneficial to minorities. One of the reasons is what I've mentioned earlier, that it's extremely hard for kids in many ghettos to get a decent education today. Let's say as decent an education as I got in the center of Harlem 40 years ago, because the disruption is so much greater today, and there's so little you can do about it. If you expel more black males from some schools than you expel Asian females, that becomes a court case. You have the American Civil Liberties Union intervening in these places. There were students, there were parents actually, parading, I believe in Chicago, with signs saying American Civil Liberties Union keep out, because they wanted their kids to get educated. That couldn't be done if you're going to have to due process every disruptive student. So I think that's been very harmful. I've seen the deterioration in crime as well. No, I don't believe that judicial activism has been beneficial to minorities.
Over the past few weeks, we've witnessed a great irony. Judge Bork states, and continually states, and has written that he believes that the people's elected representatives should determine policy in this country, not unelected, lifetime appointed judges. Yet some of those elected representatives are objecting to this nominee who contends that Congress, not the courts, should make our fundamental policy choices. Now, why do you believe that some members of this body and others who are liberal in persuasion are worried about a judge who will really let them make the nation's key decisions?
Because they will have to make those decisions publicly and stand up and vote, whereas judges can simply engage in verbal sleight of hand about constitutional clauses and make the same decisions.
I think that kind of sums it up. Fact is, it makes the hard political choices ours rather than the unelected judges.
Yes.
And that's pretty tough on people who have to run for election over and over again. And maybe they can't get some of these decisions through the elected representatives' bodies.
I suspect not. It's also very ironic to hear a man described as dangerous because he's announced that he's going to follow the instructions from Congress.
Well, Professor Sowell is the nation's leading lawyer and solicitor general, and 5 years as a judge on the second highest court of the land. Judge Bork has never advocated or rendered a decision less favorable to minority plaintiffs than the decisions already reached by the current Supreme Court. Never. Nobody can make a case that he has. Nor, for that matter, has he ever taken a civil rights position less protective of minorities than Mr. Justice Powell. Never. Frankly, we continue to hear that he might shift the balance. And I think this is very hard to justify on the facts as I view them and as I think any fair-minded person would. Indeed, in many areas, such as the Voting Rights Act and sex discrimination, Judge Bork has taken positions even more protective of the minorities than those advocated by the Supreme Court. Now, on the basis of the record, the only difference I can find between Judge Bork and Justice Powell are his statements about the Bakke case involving affirmative action. Judge Bork has said he prefers the original non-discrimination concept of affirmative action. This means that he would permit and would actively permit active recruitment of qualified minorities, among other things. The alternative, as you know, is some form of mandatory proportional representation for minorities, or quotas, to put it in one word. Now, do you believe that mandatory proportional representation benefits minorities.
No. In fact, I think one of the great handicaps that blacks and other minorities face across the country is that they are systematically mismatched with universities in the admissions process. That is, if Harvard feels that it must have X% of blacks, and if the pool is such that they can't get X% of blacks at the same level as the rest of the Harvard students, they're going to take those blacks who would have succeeded in some state university and bring them to Harvard, where many of them will fail. Or MIT is a better example, that the average black student at MIT is in the bottom 10% of MIT students in math. But he is in the top 90% of all American students in math, because MIT students are so phenomenal in mathematics. Something like 1/4 of all the black students going to MIT do not graduate. You're talking about a pool of people who score at the 90th percentile in math, whom you are artificially turning into failures by mismatching them with the school. Back in much earlier, you had a great increase of blacks in the universities through the GI Bill. You had nothing like that kind of attrition from that process, because the student went wherever he could be accepted, wherever he met the normal standards, and the government simply paid the money.
Now, Dr. Sowell, when Judge Bork says the Equal Protection Clause probably should be kept to things like race, he is not saying anything other than what he has said before this committee. He is saying that groups other than race should not be covered by the Equal Protection Clause. He said that all persons, not groups, should be covered. And
yes.
to repeat what Judge Bork said many times, one, he said that the Equal Protection Clause itself grants, quote, any person the equal protection of the laws, unquote. Thus, every person, black, white, male, female, everyone is covered by the Equal Protection Clause, according to Judge Bork. Now, when it comes to the standard, which is a separate question from coverage, Judge Bork says that only blacks are covered as a group by strict scrutiny. All other persons are protected by a reasonable basis test. Now, this test will grant women as much protection or more than they get now, according to him. In fact,
Time has been up, yeah.
Well, let me just finish with a couple more.
Okay, no, that's fine. Okay, good.
Well, I appreciate it, because this is an important issue, because I think his record has been seriously distorted before this committee, and in some ways by some of us on the committee. Now, not intentionally, I don't brand anybody that way, but I think it's hard to understand these areas. This is a very, very difficult area.
Yes, I hadn't heard that explanation before, and it does make sense.
Well, let me just say this. Besides being equal, Judge Bork's reading of the Equal Protection Clause is also fair. Under this approach, whenever an immutable trait, such as gender, which bears no relationship at all to one's ability or merit or inherent equal personhood, is the basis for discrimination, he would always hold it to be a denial of equal protection. Now, this means that almost no laws that distinguish on the basis of race or sex will be upheld by Judge Bork. And as Justice Stevens, who is known as a champion of the rights of the disadvantaged, has written, quote, we do not need to apply a special standard or to apply strict scrutiny or even heightened scrutiny to decide such cases. Now, this is because the rights of minorities and women can be and are fully protected by Judge Bork's equal protection approach without extending special advantages to one group over others.
Yes.
Now, that's what he has said. Do you find any fault with that as a minority?
Not at all.
As a professor, as a thinker, as somebody who's written extensively and has thought through, I think, more than perhaps any other person in our society, the implications of affirmative action and other minority relationships.
I not only accept that explanation, but I'm even more impressed by what he has done, because by their fruits you shall know them. And what he's done on the Circuit Court of Appeals means a lot more to me than a phrase that was lifted out in an interview on the run with some magazine.
Well, I've certainly used up my time. I want to thank you. I think that your testimony is extremely important to this committee, because the American people really aren't hearing the truth. And it is. These are intricate, difficult, hard to understand concepts. And I think it's about time they heard the truth. There's no reason for any woman to be afraid of Judge Bork or Justice Bork, as I hope he will become, or any minority person or anybody else. I think, as a matter of fact, he would apply the Equal Protection Clause the way the Constitution provides that it should be applied.
I believe that as well.
Well, thank you.
Thank you. I have not used my time. I'm going to use my 5 minutes now, if I may, and hold me strictly to the 5. Please give me a 1-minute notice. Let me ask you a couple questions. You think judicial activism, Doctor, has hurt blacks. Judicial activism of eliminating restrictive covenants in deeds, eliminating segregation in schools, one man, one vote, literacy test. Do you consider those judicially active?
Well, as regards restrictive covenants, I can see no evidence that they did anything other than make some people feel good because it was symbolic. As regards desegregation of the school system, that should have been done long before and on a much more sound basis. I've gone into this at great length in previous writings.
But are they...
No, you see, the problem is not whether you believe that school desegregation should have ended. I believe it should have ended long before. Okay. Judge Bork believes it should have ended long before. What he and what I have objected to are the principles used in that decision, because those principles take on a life of their own, and they come back to haunt you in other areas. Obviously, this old phrase, hard cases make bad law, derived from that fact. You dream up a principle to reach this result, and then the principle has a life of its own.
So the principle of desegregating the schools...
No, that wasn't the principle. The principle was the reason that they picked for it. Well,
that's all I'm saying. Okay, the reasons they picked...
Yes.
Desegregating the schools, you and Judge Bork agree were the wrong principles, and they should have not. So the court shouldn't have done that.
No, the court should have done it.
Oh, okay.
Both of us have said the court should have done it.
I see.
And in my case, and I think in his case, the court should have done it a lot sooner.
How?
They should have ruled that it wasn't equal protection of the law, because nobody in his right mind believes that there was equal protection of the law in the Jim Crow era of these school systems.
I'm just trying to figure out what you're saying.
Yes.
Now, when they desegregated the D.C. schools, it's clear the 14th Amendment does not apply. Everyone agrees that the 14th Amendment does not apply to the District of Columbia. How would they have done it in the District of Columbia? Should they have just let it stand in the District of Columbia? Segregation?
No, in fact, Senator, it's interesting that you say that, because I've gotten the first thing I ever wrote in on a public issue was in November 13th, 1950, in the Washington Star, in which I argued for the desegregation of the D.C. school system. So that
on what principle?
I had not studied nearly as much then as I have 37 years later, and so I hadn't worked it out. Nor do I think that I would want to work it out on the run in front of a large group of lawyers at this very moment in the time that's available.
Well, how about literacy test? Was it judicial?
I see no reason why people shouldn't be literate in order to vote. The question is, if you have a black who comes in with his degree from Harvard, and the man behind the desk says, no, you're not literate, you can't vote, then you see, this is what bothers me. People are talking about how judges should be sensitive to this particular group or that particular group. And if that means anything, if it means he's applying the law differently, that's precisely how blacks were held down for generations in the South.
So
by applying the law differently.
So literacy test, as long as they were equally applied, are all right.
Sure.
So I thought you thought. Now, I also want to clarify, I gather from your comments about MIT and Harvard that you don't think there's enough blacks out there who are qualified to fill the number of vacancies allotted for them in those schools. Is that right? Is that what you're saying?
Well, the word qualified really is misleading.
Well,
the question is whether or not they are like the other students at Harvard and MIT.
Well, okay. Oh, so there's not...
So they may be perfectly qualified. This same student might go through, God help us, I hope there's nobody here from Illinois, Illinois Institute of Technology and do well. But there's no reason why he should fail at MIT. There's no prestige in flunking out of the Ivy League.
I got it. So, but my point is, you believe there are not enough black women and men out there that are the same as white women and men to be able to go through Harvard and MIT.
If there were, it would mean that the whole history of oppression had done no harm whatever.
Well, so the answer is you don't think there are. I just want to figure out what you're saying.
It's not a question of what I think. It's a factual matter.
So factually, you're saying factually there are not enough.
Factually, this study's already been done by Clickguard at Harvard, and the figures are all there. Anyone can look them up.
Okay. No, I just want to hear from you. I want to know what you're thinking. Have you read all of Judge Bork's cases or any of them? Have you read all of his writings?
I haven't read all of them, but I've been reading them for more than 20 years because I used to teach antitrust economics.
Now, are you part of what they call the law and economics school? You know that? Would you consider yourself part of that school? There's nothing wrong with that. It's not a bad school. I just wondered where you are.
When I sit down to write, Senator, I don't ask what my label. I don't check my identification tag to see what I am. But well, I did. One of my books did win a prize as the best book in law and economics in 1980.
Yeah, no, but I mean, there's almost a term of art out there called the School of Law and Economics. Yes. And are you part of that school intellectually? That's all I'm trying to get.
I'm very much interested in the application of economic principles in the law and vice versa.
Right. Now, my time's up. Thank you very much. Senator from Pennsylvania.
Dr. Sowell, back to judicial activism. Aside from the legal principles, although I think there's been enough time since 1954, since the cases came down to figure out a legal principle, but just back to judicial activism, you say that judicial activism has not been helpful to minorities. You say that discrimination should have been ended long before it was. Judge Bork has written that discrimination should have been ended in the 30s and 40s, not waiting until 1954. The Congress of the United States wouldn't do anything about segregation. The state of Mississippi and the state of Georgia and the state of Kansas wouldn't do anything about segregation. If it weren't for judicial activism of the Supreme Court of the United States, there still might be segregation. Who would have done it except for judicial activism, and never mind the theories?
Senator, if the Supreme Court struck it down, it would have been struck down no matter what reason they used for striking it down.
But it was judicial activism. The point is that no one else would act except the judiciary.
Well, Senator,
and that's what you call judicial activism.
Oh, no, Senator, because as long as the judiciary has been acting, every judge, including Judge Bork, would have to be a judicial activist. That's not what the term means as he uses it.
But you have a variety of ways to end segregation.
Yes.
You have legislative activism, you might have executive activism, or you could have judicial activism. Who else is going to act?
Senator, if every time a court acts, you call it judicial activism, then every single judge must be a judicial activist, and the term would have no meaning.
Are you aware of the fact that Judge Bork has spoke forcefully for judicial activism in carrying out the principles of the Constitution?
Again, it depends on what you're defining. It's like these definitions.
Answer my question. Are you aware that Judge Bork has spoken out actively in favor of judicial activism, that judicial activism is highly desirable when you carry out constitutional principles?
I am unaware of that particular statement out of his voluminous writings.
Dr. Sowell, are you aware of the fact that Judge Bork has repeatedly said that equal protection of the law does not apply to women?
Well, Senator, we've discussed that twice, and apparently it does apply to women.
We have discussed it many times, but I don't think on the same facts. Repeatedly in this hearing room, we have cited texts where Judge Bork has said that on original intent and his construction of the Constitution before coming into this room, that equal protection of the law does not apply to women. I understood you to say that Judge Bork has ruled as a judge on the Court of Appeals that equal protection of the law does apply to women. Did I understand you correctly?
No, I was saying I know of no cases in the Court of Appeal in which Judge Bork has said that it does not apply to the women.
But that's not the point. The point is, do you know of any case on the court where you said that equal protection of the law does apply to women?
No, Senator.
Well, then on the record we have so far, and I agree that Judge Bork can change his mind, but the issue is what you know about Judge Bork's position. And Judge Bork has repeatedly said before coming into this room that equal protection of the law does not apply to women. Now, my question to you, if you had known that, would you still be as emphatically in support of Judge Bork as you are?
Senator, if there were certain words that were put together in a certain way, that means nothing. What really matters is what did he say in substance. And I think on the question of judicial activism is a classic example of that.
I don't understand you. If a group of words were put together in a certain way, what other basis do we have for judging this man? He puts a group of words together in a certain way when he writes an opinion. He puts a group of words together in a certain way when he makes a speech. He puts a group of words together in a certain way when he writes a law review article. What I'm trying to find out, Dr. Sowell, is really what you know about Judge Bork.
Well, I've read his writings on antitrust for a very long time.
Well, aside from antitrust, which we haven't gotten to, how about on equal protection of the law? How about on freedom of speech?
I've read him on freedom of speech. I've read the Indiana law article. I've read
well, if you've read the Indiana law article, it's hardly a line that he's drawn. You say that when you come to freedom of speech and clear and present danger, it depends on where you draw the line. The line wouldn't appear on the table. It'd be off the table. As Judge Bork articulated the principles in the Indiana Law Review, he says that you may not contest legality. He says that you shouldn't be able to articulate a principle of proletarian dictatorship. The clear and present danger test of Holmes is that there has to be an imminence of violence. It's not on the table, and that's a long table you have. Well, Dr. Sowell, I think that Judge Bork has a perfect right to modify his positions and come into this room. But when you have made representations about where Judge Bork stands, I have a real question as to how much you know about Judge Bork.
Well, Senator, one of the things I know is that long before these hearings, the Indiana Law Review article was brought up at a meeting of the Federalist Society at Stanford University, where I was there. And Judge Bork at that time said, well, I've been eating those words for a long time now. And he let it drop at that. He had not been nominated to anything, except he was already on the Circuit Court of Appeals.
Well, are you aware of the fact that in 1985 he was interviewed and published in a conservative magazine that he stood by his 1985 comments?
Well, Senator, I stand by what I wrote in 1972.
His 1971 comments.
Senator, I stand by what I said in 1972 as a matter of general principle, but there are many sentences and whole paragraphs that I would not repeat today, and therefore I don't want the book reprinted.
Well, aside from what you stand behind, are you aware of the fact that in 1985 Judge Bork said he stood behind his 1971 Indiana Law Journal article?
In the same sense in which I stood by my 1972 book.
Well, he didn't say that he stood behind them in the same sense that you did. He said he stood behind them.
Sure, Senator, but
and
I would say that too.
In 1987, I believe it was on WorldNet, he said that equal protection of the law did not apply beyond race and ethnics. Are you aware of that?
Well, the argument that Senator Hatch has just made is that if you're talking about persons, that's one thing, and if you're talking about groups, it's something else.
Well, he didn't say groups and persons. He didn't say groups and persons in the 1971 article. He didn't say groups and persons in the 1987 article. Dr. Sowell, my time is up, and I think Judge Bork has articulated a position in this room, as I said earlier today, which may well warrant confirmation. I'm not saying yes or no. But when I hear you say that there is, when I hear you say what you have about Judge Bork's record, I just would refer you to some of his writings. Thank you very much, Mr. Chairman.
Thank you. Senator Heflin, is that right? Senator Heflin.
Dr. Sowell, is how you pronounce your name?
Sowell, just like Lowell.
All right, Sowell, pardon me. You are with the Hoover Institute as a fellow. What is your academic background? Are you a lawyer? I should know. But
I'm an economist by trade, but I've wandered into other fields.
You have an educational degrees in law as well?
No, in economics.
Just in
economics.
Economics, all right. Just to continue a little bit on what Senator Specter was inquiring about, Judge Bork has indicated that he has shifted some of his opinions since, well, at least he's articulated changes in his opinions here at these hearings. Has this caused you any concern in predicting how Judge Bork may rule if he's on the United States Supreme Court, if on certain issues of the First Amendment or the equal protection?
Not really, because again, if you're talking about specific issues, it's always a question of how far you carry some principle. And he may carry it further one time than he did 16 years earlier. But if you're talking about the more fundamental question of the role of a judge in the whole legal system and the whole political system, that would concern me a great deal. And there, I think I've seen a great deal of consistency. In other words, the consistency I see is in the fundamental set of principles about the role of a judge in the law. And these inconsistencies are about specific issues. Maybe he would go a little further this way, a little less far that way. That really seems to me secondary.
You mentioned the school systems and indicated you didn't think that the decisions of the courts which brought about desegregation. Are you saying it, as I understood you, that you used the phrase judicial activism, hadn't helped minorities?
Oh, no, Senator. I've been
Maybe
for
I
those.
misunderstood you.
Oh, no. What I said was that I thought that the desegregation not only should have taken place a lot earlier, but a different set of reasoning should have been used.
Well, how do you, as I understood it, you were saying that the court action hasn't helped minorities.
Oh, I'm saying that at all. That's the problem with pat phrases like judicial activism, because everybody means something different by it.
Well, what do you mean? I just was curious about how you say that the school children who are blacks in a desegregated school haven't been helped. That's just what I understood you to say.
No, I'm saying that by using the kind of reasoning they did, drawing upon principles not in any written document anywhere, any legal document anywhere, but on, for example, the famous doll tests of Kenneth Clark and so on. If you buy the line of reasoning they give, then you have a definition of segregation for schools, which is totally different from the definition of segregation in any other institution in our society. That is, by the definitions that are used in schools to start busing, Dulles Airport is segregated. This room may be segregated, for all I know, by those percentage decision, representation things.
Well, I didn't understand, just to clarify my own mind as to your testimony, I didn't exactly understand what you had in mind when you said something about the restrictive covenants. I assume I don't remember the exact words, but in effect that the decisions that eliminated restrictive covenants haven't benefited.
Well, I know of no one who has even claimed that there's been any discernible difference in the housing pattern brought about by either Shelley v. Kramer or Reitman v. Mulkey.
In other words, you say that there's been no change.
I'm saying of that era. Now, over a long 30-year period with lots of economic changes, then you may have some gradual changes. But even so, it's been fairly minuscule.
All right, I believe it. Tell me about 30 seconds, so there's no point in asking another question.
Who is not, Senator from New Hampshire.
Thank you, Mr. Chairman. Dr. Sowell, you grew up in Harlem.
Yes.
Safe to assume you were not born with a silver spoon in your mouth?
I think that's very safe, Senator.
From which universities do you hold degrees?
Harvard, Columbia, the University of Chicago.
Harvard, Columbia, and the University of Chicago.
That's right.
You were a nationally syndicated columnist?
Yes.
At one time, you were pretty far over on the left of the political spectrum, were you not?
Yes, I was. I was a Marxist.
You were a Marxist.
So I have great sympathy with people who've changed their views over the years.
I was coming to that. You would say your views have matured as you have matured in age?
Yes.
You are a man of brilliant mind, obviously. Supposing you were now being considered, supposing you were sitting there right now as a nominee to a high federal position, and you've been offered high federal positions, which you've turned down, but supposing you were sitting there as a nominee in the confirmation process, would it be fair for senators to repeatedly refer to your statements as a Marxist as the principal basis for granting or denying confirmation?
I would think not, Senator.
Would it be fair or unfair for them to look at your more recent statements, even within the last 2, 3, 4 years?
Oh, it certainly would.
Would you object if we suggested you were opportunistic because in recent years you've changed your views?
I would think not.
Would it be a new kind of discrimination if we denied you confirmation on the basis of your previous views?
Well, I don't know if I would characterize it that way or not, but certainly it would not be.
Well, I would, and that's exactly what's going on here. It's a new kind of discrimination. In regards to the statements, largely misleading in the last half hour on the subject of Robert Bork's views on First Amendment, on 14th Amendment. Let me read this from page 113 of the transcript. Judge Bork speaking. Excuse me, that's the wrong part. I have no talent at all in managing paperwork. Page 57. Judge Bork. I cannot say enough, going on further. You know, beginning with the Brown versus Board of Education, 1954, I think it was, I have supported black equality. And I have done that in print long before I got here. I've never said anything or decided anything that should be frightening to women, and so on. I ask unanimous consent to put that back into the record. Now, here's another interesting facet of this whole discussion, Doctor. There are those here now, those who've appeared before us, who apparently believe that only judges could have broken down the barriers which held back black Americans, that only activist judges are responsible for the gains which blacks have made in our society. Now, I remember well the 1960s and the civil rights struggle, because I was out there in, what was it, 1963, in that sea of people protesting the inhumanity and the immorality of racism and discrimination. And I say to those who suggest that only judicial activists and only judges could have broken down those barriers, that you are insulting all of us, including yourselves, who participated in the great civil rights struggle, because political activism would have broken down those barriers, maybe not quite as soon, but very nearly as soon as judicial activism broke them down.
Yes, the other thing, too, is that if you look at history, and again, I think that's appropriate when you're talking about something like the Supreme Court, it's by no means clear from history that judges have been more sympathetic to blacks throughout history than the legislature or the presidency. From the time of the Dred Scott decision until Plessy v. Ferguson was a longer period of time than from the time that Earl Warren came on the Supreme Court to this very moment. And during that period, the courts were the lagging element, and it was the president and then the Congress that
Indeed it was. Indeed it was. And to suggest that blacks would have lain supinely and put up with that kind of discrimination for even another 5 years or 3 years or 2 years is to insult the black Americans, I believe. Indeed it was political activism and indignation on the part of blacks and those who sympathized with them, more than judicial activism, which resulted in passage of civil rights statute. It was political activism, not judicial activism, that emancipated blacks in the fullest sense of the word. How do you feel about black Americans who have come before this committee and have opposed confirmation? Do you think they serve the black community well?
No, I don't. I don't know what all their reasons are. One of the sad things that happens with any organization over a period of time is that as it fulfills its mission, it looks for new missions, because organizations don't die quietly. And I think there are many, many problems that need to be addressed in the black community. Not all of them can be addressed with either the rhetoric or the strategies of the 1950s. But people tend to, generals fight the last war over and over again, and I think that's what's happening here.
I think so, too. I wish I had more time. Thank you.
Time is up. Senator Thurman, are there other members on the minority side who wish to, who have not had a chance to? Thank you. Then we will stand in recess until 2:15.
You've been watching this morning's proceedings before the Senate Judiciary Committee as members continue hearing testimony of the nomination of Judge Robert Bork to the Supreme Court. In just a moment, we'll return with this afternoon's session. Stay with us.
You're watching C-SPAN, America's network. C-SPAN is a nonprofit cooperative created and supported by the cable television industry as a public service for its national cable television audience. In addition, C-SPAN is underwritten in part by the following.
C-SPAN's operations are underwritten in part by the TLL Temple Foundation of Lufkin, Texas, supporter of charitable and educational projects, primarily in East Texas, and now public affairs programming on cable television.
To some 14 million customers in the Southeast, and to a world entering the age of information, we are a leader in the application of technology that provides new ways for people to communicate. Bell South, shaping the future of telecommunications.
Thousands of C-SPAN update readers knew in advance about our coverage of the confirmation hearings of Supreme Court nominee Robert Bork. The C-SPAN update helps you better plan your C-SPAN viewing time by giving you information on major telecasts like the Bork hearings, our Road to the White House series, National Press Club speeches, and more. Call 1-800-453-4003 to order 50 weekly issues of the C-SPAN update. When you do, we'll send you a free copy of Gavel to Gavel, a 64-page guide to the televised proceedings of Congress.
Coming up next on C-SPAN, we resume our coverage of today's Senate Judiciary Committee proceedings on the Supreme Court nomination of Judge Robert Bork.
We began this afternoon with a distinguished panel indeed. We're delighted to welcome you all here and apologize for your having to be here on Friday afternoon. But as you well know, this is an important issue, or you wouldn't be here, and we're anxious to hear what you have to say. Our panel is made up of 4 witnesses. First, Shirley Hufstetter. She has served as Secretary of Education and as a Federal Circuit Court judge for the 9th District, and currently is a practicing attorney. And it's a great pleasure to have her here. Second is Barbara Babcock. She served as Assistant Attorney General for the Civil Division. Currently, she's a professor of law at Stanford Law School. She's an author of articles on equal protection, federal courts, and judicial procedure. And third is Wendy Williams. She's a professor of law at Georgetown School of Law, and she too has authored articles on equal protection clause and especially on gender discrimination. And finally, Sylvia Law, who is a professor of law at New York University College of Law, School of Law. She teaches in the areas of family law and federal courts, and also has written on equal protection issues. I'd like to welcome all of you here today. And if we can, Madam Secretary, if we could begin with you first, and if you would all sort of unsheathe those microphones there. So, and the closer you can pull them to you, the better everyone can hear in the back. And if you would begin, Madam Secretary.
Thank you, Mr. Chairman. The nation now needs a great moderator as the next Associate Justice of the United States Supreme Court. That person must have the ability to help the court maintain the delicate balance that the Constitution must preserve if it is continued to be the stabilizing yet dynamic force that it is in our country today. We would have no reason to celebrate the 200th birthday of the United States Constitution if we had not built and preserved the institutions necessary to enforce it and to use its grand ambiguities to meet the immense challenges in transforming 13 quarreling colonies into the greatest free country in the world. Without the creative power to interpret the Constitution, we could not have managed to save our freedoms through devastating wars and multiple revolutions in geopolitics, economics, technology, and society that have moved us from the isolated agrarian world in which our country was born to the interdependent, pluralistic, industrialized, urbanized nation we have become. The institution that has been most critical in shaping the Constitution to perform these tasks is the United States Supreme Court. The role that that court plays in American government is unique in the world. The Supreme Court's existence is rooted in the Constitution, but its power in American life has evolved from a series of decisions by unusually distinguished justices who interpreted the document, most particularly the Bill of Rights, to give it the living force required to obtain obedience to our constitutional system of checks and balances controlling the 3 branches of federal government and the relationship between states and federal sovereignties. The Supreme Court has become, in this nation, the final arbiter of those issues that most deeply divide our people from one another. The court's role began evolving under the leadership of the great Chief Justice John Marshall with the decision of Marbury against Madison, establishing the power of the court to declare a legislative act unconstitutional. The struggle to adapt the role of the court and the Constitution in a changing society is constant. When the membership of the court has proved unequal to its task, the nation has been imperiled. The nation could not endure half enslaved and half free. When the Dred Scott decision did not free the nation from the bondage of slavery, that failure was a precipitating cause of the Civil War. When a majority of the justices were unable to accommodate their 19th century views of the Constitution to meet the urgent demands of the United States in the 1930s, the majority imperiled the court itself. Today, the court is sharply divided. The members of the court speak not only for themselves. Their dissonant voices reflect the views and needs of millions of Americans, rich and poor, women and men, young and old, powerful and powerless, black, white, and brown. To bring our people together in principled accommodation of our differences, to prevent one branch of government from overwhelming another, and to prevent any changing majority or any vocal minority from trampling the fundamental freedoms of those with whom they disagree. The nation needs a gifted moderator on the United States Supreme Court. Justice Lewis Powell was a gifted moderator on the Supreme Court. His plurality opinion in Regents of the University of California against Bakke was the work of a statesman. Our tragic inheritance from slavery and the Civil War, racial apartheid, had been gradually dismantled by the Supreme Court. No other institution of government had the combination of power, life tenure, and moral authority to do it. Affirmative action to redress invidious racial discrimination generated the same fears that had earlier prevented apartheid from being resolved and that still linger in the smoldering controversies over the emergence of the rights of women and minorities in America.